Is a coincidence.
She told me she thought he was weird. They said he got her address from her medical records.
By now, you're familiar with the Health Insurance Portability and Accountability Act, or HIPAA, and the privacy rule that affects your work. To you, this rule may be another item in a long list of procedures to remember. But to patients, an unauthorized disclosure of information could be life-altering. Information placed in the wrong hands could jeopardize patients' reputations, job security, or even their personal safety.
Today, you'll learn the guidelines for using, disclosing, and guarding protected health information, or PHI, through several real-life scenarios. Pay attention. Your compliance with the HIPAA privacy rule could mean the world to your patients. As you know, the HIPAA privacy rule restricts the use and release of medical records and gives patients more control over how that information is used. By law, healthcare providers, health plans, and healthcare clearinghouses, what HIPAA calls covered entities, are now held accountable for privacy violations with serious penalties for noncompliance. In this program, you'll hear the term protected health information, or PHI, used often. PHI is any portion of the medical record regarding a patient's physical or mental health, healthcare services, or payment that contains personal information. Personal information is any information that matches patient to record, such as name, address, social security number, or physician notes. According to the privacy rule, patient permission or authorization is required before using or releasing PHI. However, the rule was not meant to get in the way of prompt and effective health care. There's a certain amount of use and disclosure of PHI that just goes with the territory. HIPAA calls it incidental use and disclosure. Communication and caregiving go hand in hand. HIPAA was not intended to stop you from doing your job. You are required to make reasonable efforts to safeguard patient privacy, activities many of you already do to protect the privacy and dignity of your patients. It's common sense for many. When discussing patient care with other professionals, try to avoid public areas or elevators. If that's impossible, avoid using the patient's name. When you're talking to patients, draw the curtain and try to avoid being overheard.
You're also expected to limit the amount of protected health information you share to the minimum amount of information necessary to get the job done right. This requirement, called minimum necessary, is a basic premise of the privacy rule.
Your facility should have systems in place to limit access to PHI based on who needs it to care for the patient. The rule doesn't apply to treatment. That's a given. Healthcare providers need access to the entire record for treatment. In most other cases, you're expected to limit use and disclosure on a need-to-know basis. Now let's see if you can identify permitted uses and those that are not. This nurse and doctor are discussing a patient in a public area. However, they are speaking quietly and not using the patient's name. Therefore, this action is permitted. What about this hospital employee who wants information about a friend? Not permitted. This employee works in purchasing and does not need access to his friend's PHI to do his job. Special computer screens can be used to prevent anyone from reading information unless he or she is directly in front of it. Some screens can automatically log off if a terminal is not used within a set time frame. This chart is sitting unattended outside an exam room. Permitted or not permitted? You're correct if you said permitted. You can still maintain patient charts at the bedside for monitoring purposes or outside exam rooms with patient names on the chart. Make sure hallways holding charts are monitored and leave medical charts turned toward the wall. You can also post key information such as high fall risk or diabetic diet on patient care signs at the bedside or on the door. This nurse is in a public area and is calling a patient about a scheduled appointment. The action is permitted as long as the nurse limits the information she discloses, especially when leaving a message. For instance, leave your name and number when confirming an appointment, or ask for a call back. If a family member or friend answers, you are permitted to disclose limited information regarding patient care, as long as it's in the best interest of the patient. This is a common site, a sign-in sheet for patients, permitted or not. This is a permitted use, but limits sign-in data to protect privacy. For instance, don't include a space for the reason of the visit.
Can you imagine if you had to get written permission from a patient every time you use the medical record for treatment or billing or daily healthcare operations? It could be a nightmare. For this reason, the rule does not require patient authorization for treatment, payment, or healthcare operations.
You are expected to limit the amount of information shared, except, of course, when it comes to treatment. Let's review some examples of these permitted uses. Healthcare providers talking about their patient. Permitted. A secretary scheduling a surgical procedure. This is a permitted use for treatment. Using PHI to file a claim for payment. Permitted. A nurse faxing a copy of PHI to a specialist who needs information to treat a patient. This use is permitted as long as she takes steps to make sure that the information being sent is received by the intended person only. For example, this nurse called the office first to verify the correct fax number. She also made sure someone was standing by to receive it. There are other times when the minimum necessary PHI can be shared without permission or authorization. In the interest of public health and safety, for instance, to control and prevent disease, to report victim abuse, and to monitor the safety of FDA-regulated products. For health oversight activities to ensure quality of care. For certain law enforcement purposes, and to comply with a HIPAA investigation.
PHI can also be used or disclosed for certain purposes as a limited data set when all personal identifying information has been removed. Your privacy policies detail these exceptions. Make sure you follow them.
For all other uses, a signed authorization from the patient is required to use or release a patient's PHI. Let's look at a few examples. Patient authorization is required for use and disclosure of psychotherapy notes about private counseling sessions. With some exceptions, authorization is required before using or disclosing PHI for marketing, which can include anything used to encourage recipients to purchase a product or service. Selling patient names and addresses to third parties is one example where you would need authorization. If you're informing patients about services of specific benefit to them within your facility, such as a weight loss class, referring a patient to a specialist for a follow-up test, or recommending alternative therapies for treatment, it is not considered marketing. Finally, patient authorization is required for research purposes, such as clinical trials, except when a waiver of authorization is obtained from the Institutional Review Board or a privacy board. Remember to document it whenever you get a signed authorization and keep it on file for at least 6 years. There are circumstances when authorization is not required, but you need the patient's agreement to use or disclose PHI. For instance, to inform family members or others involved in the patient's care, to maintain your facility's patient directory, or to inform agencies during disaster relief efforts.
For patients, and that includes each one of us since we all have medical records, the rule means we can now make informed choices about how our personal health information is used.
Patients can now find out how their medical information is used and request a history of non-routine disclosures. Non-routine disclosures do not include disclosures for treatment, payment, or healthcare operations, or those that were authorized. They can examine their personal medical information and request copies and corrections. They can receive your facility's written notice of privacy practices. They can also request restricted use and disclosure of their PHI, although your agency is not required to agree in all cases. As a healthcare provider, it's your job to make sure your patients can exercise their rights. For instance, patients have the right to inspect their PHI without explanation as to why. And there are no limits on the number of times they can make a request. However, you do have the right to ask that the request be made in writing. Remember to document requests from patients for copies of PHI and all other requests, and file them. Patients are not permitted to access psychotherapy notes from their private counseling sessions, or information compiled for use in litigation. Use your professional judgment. If you believe the information could cause harm to the patient or endanger staff or anyone else, you do not have to agree. If access to PHI is denied, you are required to give the patient a written explanation of the reason and a description of how the patient can complain to your facility's privacy officer or directly to the Department of Health and Human Services, HHS. Basically, the privacy rule asks healthcare providers to give patients a Miranda, a reading of their rights, in written form. It's called Notice of Privacy Practices, and it outlines your facility's privacy practices. The notice includes a statement that your facility is required by law to maintain the privacy of patient PHI and lists patients' rights over their own PHI. The notice also states how patients can exercise their rights and make complaints. It's your job to make sure you understand the privacy practices fully and to make sure patients have a copy of the notice, no later than the date of first service delivery. In emergency situations, provide notice as soon as the emergency is over. Make a good faith effort to get the patient's written acknowledgement of their receipt of the privacy notice.
What about patients who are legally or otherwise incapable of exercising their rights, or patients who choose to designate another to act on their behalf?
In these situations, someone else has the authority to make healthcare decisions. Examples include the parent of a minor child, a court-appointed legal guardian of a mentally incompetent or otherwise incompetent patient, or someone with legal authority to act on behalf of a deceased patient or his or her estate. In these cases, a designated personal representative acts on behalf of the patient and exercises that patient's rights. The personal representative may inspect the patient's PHI or obtain an accounting of non-routine disclosures. All the rights normally exercised by the patient apply to the personal representative. Sometimes legal authority is limited to specific healthcare decisions. For example, a personal representative may only have power of attorney regarding use of artificial life support in a medical emergency, and therefore only have the right to the PHI needed to make that decision.
How can you be certain someone is a personal representative? Well, the same way you've verified representation in the past. State laws determine patient representation, so HIPAA doesn't address this.
Now, let's look at situations involving personal representatives when use and disclosure is permitted and when it is not. This parent wants to inspect her 10-year-old daughter's medical record. Permitted? Yes. A parent does not need to explain a request to see a child's medical records, although in some cases you may need to verify identification. Parents of a minor child are by law the personal representative with the authority to exercise their child's rights, unless a court grants authority to an adult other than the parent, or unless prohibited by state laws. For example, some state laws maintain that parental consent is not required for an adolescent to obtain certain mental health services or medical procedures. If you suspect that the personal representative has subjected a minor or adult to domestic violence, abuse, or neglect, or if you believe disclosure to the representative could endanger that patient, the rule allows you to decline disclosure. This man is asking to see his wife's medical records. This use is not permitted, since the patient's husband does not hold power of attorney, nor is he legal guardian. If the patient is present and capable of making decisions, get the patient's agreement first. It can be an oral agreement, or give the patient a chance to object. If the patient is not present or hasn't agreed prior to disclosure, or in an emergency, use your professional judgment to decide whether disclosure is in the best interests of the patient. For instance, relatives or friends who accompanied a patient to the ER can be given information about the patient's progress if the patient is incapacitated.
You might think of HIPAA as just regs, but it's actually a federal law, with civil penalties of up to $25,000 per year and criminal penalties that can escalate to $250,000 for conspicuously bad offenses.
There are systems in place to make your compliance with HIPAA easier. Your facility has a designated privacy official who's there to help you follow the privacy rule and to assist with any questions or concerns. The complaint process, which applies to patients, employees, or anyone else registering a complaint, is outlined in your facility's Notice of Privacy Practices. You're required to document all privacy complaints as well as their resolutions and keep them on file for 6 years. HHS is required to give you and your facility advice and technical assistance and help you work out problems if you inadvertently make a mistake.
You can keep mistakes from happening by taking an active role in preventing and reporting privacy breaches like these.
This transporter is a friend of the patient. However, he is not permitted to use this PHI. This is a deliberate violation of privacy. Make sure hallways holding charts are monitored and leave medical charts turned toward the wall. Here, this same employee is talking to his coworkers about the patient whose records he should never have accessed. If you overhear conversations like this, don't be shy about speaking up or reporting the violation. This woman, the wife of a well-known political figure, was a victim of domestic violence. 1 hour later, a man arrives claiming to be her brother. What do you do? Use your professional judgment. If a person accompanies the patient to the facility, checking ID may not be necessary. This man is a reporter who gained access to the victim's medical information. This privacy breach could have been prevented if someone had asked for identification. This man asked to see his 7-year-old daughter's medical records. He was denied. Luckily, the nurse he spoke to had been on the floor when the child was admitted with multiple lacerations around her face and neck and severe dehydration. The medical staff believed the child was a victim of abuse. Always use your professional judgment. If you believe that releasing medical information to anyone, even a legal personal representative, could endanger the patient's life, you are permitted to deny access. This patient is asking to inspect his own medical records. However, he has a documented history of mental instability and violence. What do you do? Always look over the person's record before using or disclosing information for any reason. If you believe there is a safety risk to the patient or others, do not hesitate to say no.
Keep in mind that HIPAA is not intended to override your professional judgment or standards of care. HIPAA knows you are the experts on the front lines of protecting your patients. When you do your job and exercise your professional judgment, you protect everyone's right to privacy and promote quality patient care.